Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Let's start in Maryland. I love Maryland. And, this is, I think, a good case for instruction, right? So we have a 46-year-old recruit, very important, recruit. He was terminated in Howard County. He was terminated from the fire academy in 2018. So this has been going on a long time. His lawsuit has now been dismissed prior to a trial after what's called a motion for summary judgment. And just for the viewers, that means that there's no issue of fact that the judge felt precluded making a determination on the law. So that's what summary judgment is. According to him, because I believe he's 51 or was 51 years old at the time, he believes he was terminated for age discrimination. And
he was 46. There was reference to another case where there's I think, a firefighter from Milwaukee that was 51. So I think he was 46.
Okay, good. Perfect.
Yeah.
Which, look, is older for a recruit. I mean, let's be fair, it is. But
honestly, I'll give you my bias. I would not want to be a brand new firefighter at age 46, especially not in a career department. Am I being an ageist? I'm 66. I think I'm in the class I'm criticizing. Yeah. But I would not want to be a recruit.
I agree.
If they're physically able, then they have the right to. That's a separate.
Be a super strong guy.
Right.
So here, nonetheless, the court does a really good job, and I like this for instructional purposes. This could be a law school 101 case. It really is. So look, he sues under the Age Discrimination Act, which protects persons 40 years of age or over, which he meets. The court reviews what he's got to prove. And they said, listen, he's got to prove by a preponderance of the evidence, which, by the way, is not a huge burden, right? I mean, that's not clear and convincing. Like
more likely than not. More likely than not.
Yeah, that's not a big burden not to be able to make. So to lose here is tells you something. In any event, basically they have to show that but for him not being a certain age, he wouldn't have been dismissed. And they can use, the court says, direct evidence of, derogatory statements or whatever, but or even some indirect evidence. And if there's no direct evidence, we're going to go to what we always do on every show, the McDonnell-Douglas balancing test, which, boy, people can get a PhD in that right now if they watch enough. In any event, the judge then goes through it and he says, listen, he put in some proof that a captain had referred to him as old guy, right? And he said that's not enough. The court says, if that's what you got, that's not enough. And then apparently, after the determination was made to hire or to terminate him, they were, looking at, well, this captain also criticized the hiring, of another guy. This was the one you're referring to, the 51-year-old rookie firefighter in Milwaukee. And because the captain made some derogatory comments about that, he said, look, that shows his bias. But those comments were made after he was decided to be terminated. But more importantly, the judge gets to is what was the true reason for his termination? And the judge issues some really, and I call it quotable language because I'm going to use this in a lot of my cases. And because the court says, listen, our sole concern is whether the reason for which the defendant, the employer, discharged the plaintiff was discriminatory. Right? That's their sole concern. Do they have a legitimate separate reason, but for his age, they would have terminated him? And the court says, I really like this, that the court does not sit as a kind of super personnel department weighing the prudence of employment decisions made by firms charged with employment discrimination, right? I love that. It's basically saying if you've got a belief that they did something wrong, that's enough for us, as long as it's a good faith, true, non-pretextual belief. And here they simply said the plaintiff failed to come forth with anything other than he was insubordinate, he complained, he quit, he stopped doing some drills and training at the academy. They had a whole bunch of reasons to say, you're just not cutting it. And those had nothing to do with his age. So they threw it out at summary judgment. I'm impressed because again, summary judgment says no factual questions. And for him to say, look, he reviewed everything he had, all the proof he got, 2 comments, right? And he said, that's not enough to prove age discrimination. It's just not. So
yeah, and I think it's a good example of something that I teach in my HR classes is the fundamental difference between most employment discrimination lawsuits and a lot of our operational types of lawsuits. For example, let's say we have a house fire and someone gets killed.
Hey, that's coming up.
Right. The next thing that's going to happen is that there's probably going to be a lawsuit and so on. Okay. Think about an apparatus accident. You have an apparatus accident, somebody gets killed or injured, you're going to have a lawsuit. Okay. And I think lawyers, excluding you and I, okay, I think lawyers tend to have that model for litigation, which is not accurate for HR type cases. And the metaphor I use is a series of dominoes. And in order to get a discrimination claim, it's not going to be just one thing. Okay, now it could be if somebody calls you in, for example, in this case, the city calls them in and says, we're firing you because you're 46. That's direct evidence.
Pretty good.
It never exists. It
Right.
never exists, but that's sort of the equivalent of a vehicle accident. Okay, you have that one direct thing. So you're in this indirect, and you have these series of dominoes. And to me, each of those dominoes represents an interaction in the workplace that leads to frustration and despair on the part of the employee. And so a comment here, a comment there, a joke here, failing something at the academy, okay? A write-up
treating other people differently.
Exactly, okay? But each of those things, but in order to make a case, there has to be a series of things. It's not just one, an apparatus runs a red light and all of a sudden there's liability. It's got to be a series of things. And in this case, you didn't see a series of things. You saw 2 things, okay? 2 comments, one of which happened after the guy had already been fired. And you also, on almost like a separate track, you have all of these things that the city or the county here had documented that he just, he wasn't cutting it on these other areas. So I think, to me, that's a fundamental difference between our incident-related lawsuits and our HR lawsuits. There's going to be a series of things in here. 2 things just didn't add up to it.
And, one comment of I did this one thing on one occasion because that you fired me, that's a tough stretch to make for a lot of people.
Yeah, I mean, if it's really serious, that's one thing, but usually it's not. And trying to make the connection, it becomes problematic.
Exactly.
So.
And look, I suspect he was going to try to say failingly so, well, the reason I can't do the things at the academy is because my age. That still would have failed. Have failed. It's one standard, regardless of your age, regardless of anything, you've got to be able to meet the standard. He couldn't meet the standard. So they had one of the
elements of the McDonnell-Douglas test is that you're otherwise qualified. And he couldn't get past that one. So that's the challenge. Yeah.
This to me, when somebody, I'm not trying to criticize the guy, but at least according to the court, where he's not finishing drills and he's quitting on the training, well, maybe that, is the same reason he's the sort of guy who says, well, I'm not taking any blame for failing.